everybody. This is Tonetta with Tonetta Buys Houses. I want to say good morning to you all and thank you all for being here. This is actually one of the other parts I'm going to be talking to you about today about the Missouri Landlord-Tenant Law. This part is going to be talking about the repairs done to the apartment and things like that, just so you all can know who's responsible for what the landlord is responsible for, and what the tenant or the renter is responsible for as well here in the state of Missouri. And I know I keep saying Missouri, but I know every state has these laws. In your state, you're probably going to have to look up at your, I think it's Attorney General's site. I want to say that's where I got this from. Hold on, y'all. Trying to make sure, y'all. But I want to say it's the Attorney General's website. Yes, it's the Missouri Attorney General. So like I said, every state has their own, of course, their own state government, and there's always an Attorney General. So make sure that you're looking at your your state Attorney General's website to find out what your landlord and tenant's rights are. They may be similar to Missouri, I don't know, but definitely make sure that you're checking them out, and I'm sure they have this brochure on there for free as well, y'all. I'm sure that. So, excuse me, I want to thank you all again for, of course, tuning in. This is Tonetta again with Tonetta Buys Houses. And keep in mind, if you know anybody, of course, that's looking to sell their house because of foreclosure or any kind of other need, definitely send them my way, y'all. And let me go ahead and get started. The first thing is talking about repairs. One way to avoid problems with repairs is to have a written agreement, preferably in your lease. The agreement should state which repairs are the landlord's responsibility and which ones are the tenant's responsibilities. The landlord should be responsible for repairs caused by ordinary wear and tear and natural forces such as the weather. Tenants should pay for damages resulting from their own negligence or negligence of a guest. So like it just said, the repairs and those kind of things, the written agreement that you have, the lease agreement that you have, all those repairs, who should repair what, should be in your lease. And if it's not, make sure that you write a statement at the bottom about who's responsible for what, and you or your landlord have to talk about it, sign off on it, add to it, whatever you want to do. But like I said, all the leases I've ever seen, it's always been a section about repairs in the lease or just stated throughout. So make sure that's in your lease. If not, write up one, but you and your landlord, so you all can sign off, and of course date and all that kind of thing as well. Don't go without it. Oh, and I do want to say again, like I said in the other videos, that I'm not an attorney. I'm actually a social worker, and I've been in the field for a little bit over 20 years now, and I've worked with a lot of the last, not these last 4 years, but 10 years before that. Actually, over 10 years. I was working with a transitional housing program, managing the apartment program as well, and 12-unit apartment building, stuff like that. So, and doing the admissions and all that kind of stuff into the regular transitional housing program. So I have a lot of years in the housing, I guess I put it that way. But like I said, I'm not an attorney. I am a social worker. So if you have a specific need, definitely reach out to your local attorney, or if you don't have enough income, that kind of thing. Always keep in mind that legal services for Eastern Missourians, you can always contact them, and they will take cases for free on an as-needed basis and as-is case-by-case basis too. So make sure that you contact them. They are located here in St. Louis. I believe their corporate office is over on Forest Park, I want to say. Forest Park is near, I guess, like in Midtown St. Louis. So if you need that kind of assistance and there's something dire going on, please reach out to them with your concerns and the help that you need. Getting back to the repairs. If repairs are needed, ask the landlord to make repairs within a reasonable period of time. If repairs are not made, make a written request for the necessary repairs and keep a copy of the letter. If the repairs are still not made, the tenant may seek legal assistance. Again, if you need the legal assistance, like this just said, legal services for Eastern Missouri, they can be a legal service for you, and they are free attorneys actually, but they only take so many cases per year. Where am I at? Okay, if the dwelling becomes unsafe due to the repair problems, the tenant should contact the local health or housing authorities. So always keep in mind that every city that you're in, I don't care if you're here in St. Louis, you're here in Missouri, you're in Kansas, you're in California, you're in New York, wherever you are, if your housing becomes unsafe, whether the ceiling's falling in, you got black mold all around the place, you got rats, rodents, different things in the whole building, something like that is going on, or bed bugs or something like that, keep in mind that you have to contact, especially if you're wanting some assistance, you wanted to bring that landlord to justice to get things done in your housing up to code. Make sure that you're contacting the local health or housing authority. The local health, the city department of health, every state and every city has that. or every town has that, I guess I put it that way. Here in St. Louis, ours is down at City Hall. St. Louis City is down at City Hall. And the St. Louis County is out there, the St. Louis County government building. So just make sure that you all keep that in mind. And the housing authorities, we have several housing authorities here as well. We have the St. Louis City Housing Authority over on Page. And then there's another housing authority out in St. Louis County, I believe on Natural Bridge Road. But like I said, there are several throughout the state as well and the cities that we live in. So make sure that you keep that in mind, y'all. If a tenant withholds rent payments until repairs are completed, the renter may be in violation of the lease and subject to eviction. Just keep in mind that you cannot withhold your payment of your rent because your landlord hasn't fixed something. So just make sure you keep that in mind. Like this just said, you may be in violation of your lease and may be subject to eviction. In most circumstances, a tenant has no right to withhold rent. Missouri law provides only a narrow exception to this rule for dangerous and unsanitary conditions that a landlord fails to fix. And if that's the case, make sure that you have a paper trail of everything that's going on, pictures, photographs, videos if you need, and that you have contacted these people at the local, like the local health, health department and the housing authorities if they are involved in your case as well. Make sure that you're contacting those folks and leaving a paper trail so that you have documentation that you've tried to contact the landlord, you have text messages or you have voicemails or whatever, you have letters that you have written. I always say, and this, it may say that in here as well, but anytime that you're wanting a repair done, please make sure that it's in writing, it's dated and it's signed, and that you send it to your landlord. I put it that way, you keep a copy for yourself. I'm just saying that for future notice. Like I said, I've been in court before with different people, evictions and things like that, and the judge always asks if they don't have it in writing, it did not happen. So make sure that you have things in writing, y'all. Only under these very limited circumstances may the tenant make necessary repairs and deduct the cost from their rent. The condition affects the sanitation, security, and habitability of the property and violates city code. And there's a few of these that the only ways that you're only allowed to not pay rent and fix the problem is if, like I said, the condition affects the sanitation, security, or habitability of the property and violates city code. If the landlord disputes this, the tenant must obtain written verification from city inspectors as to the code violation. So you do have to be up and up on your codes to make sure that you know what's going on. The city codes are actually, they should be online. They're free for anybody to read. But I would suggest if you're looking at something like that in your building or your renter and something's going on, your landlord hasn't fixed his black mold or whatever's going on, contact the city health authorities and they will come out to do the inspection. Now you may have to pay for that, I don't know, but you will definitely talk to them when you call and ask that. The second one, the tenant has lived on the property for at least 6 consecutive months. The tenant has paid all rent owed. The tenant is not in violation of the lease. The tenant has provided written notice to the landlord of the problem and the tenant's plan to fix it. The tenant has allowed at least 14 days for the landlord to respond to the notice. So make sure that you all know all that. I'm going to read that again. Starting from the beginning. Hold on, y'all. Oh, Lord. Okay, only under these very limited circumstances may the tenant make the necessary repairs and deduct the cost from the rent. The condition affects the sanitation, security, and the habitability of the property and violates city code. If the landlord disputes this, the tenant must obtain written verification, y'all, written verification from city inspectors as to the code that's violated. The tenant has lived on the property for at least 6 consecutive months. The tenant has paid all rent owed. The tenant is not in violation of the lease. The tenant is provided written notice to the landlord. And like I said, written, not verbal, anything along those lines. Make sure it's in writing, signed, and dated by you and sent to this person. Excuse me. The tenant has provided a written notice. I just said that. Oh, well, provide the written notice in your plan to fix the problem as well. Make sure that's in your letter as well. And the tenant has allowed for at least 14 days for the landlord to respond to the notice. So if that person, I'll read the next sections as well. If the landlord still does not fix the code violation within 14 days of receiving the city's notice, then that tenant can proceed with the repairs. And that's the only time that you can proceed to fix anything in your apartment is if the landlord still does not fix the code violation within 14 days of receiving the city's notice, then the tenant can proceed with the repairs. The amount of the repairs must be verified by receipts. In most cases, the cost of the repairs must be less than $300 or 1/2 month's rent, whichever is greater. So that means that if your rent is $1,000 and the repair takes $600, I don't know. Well, I'll just read that over because I don't want to mess anything up or skew anything. The amount of the repair must be verified in receipts. In most cases, the cost of the repair must be less than $300 or 1/2 month's rent. So if it's $1,000, $500, or whichever one is greater. I'll put it that way. I'm trying to see if there's anything else. So that's the end of that, y'all, about repairs, so that you all can be, of course, abreast on what the landlord is supposed to fix and what the tenant, yourself, the renter, is supposed to fix. Like I said, if it's a landlord issue,